Welcome to another virtual panel discussion of the Centre for Geopolitics at the University of Cambridge. For the next hour, we will be discussing responsibility to protect, R2P, international justice, and the battle against impunity. The responsibility to protect populations from the four mass atrocity crimes of genocide, crimes against humanity, war crimes, and ethnic cleansing is closely related to the anti-impunity norm, which seeks justice for the victims of these horrible crimes. This is not only based on the principle of justice for the victims, but also the idea that holding perpetrators responsible and submitting them to the judgment of the law is itself an important mechanism for preventing future atrocities. And we convene this discussion at an important moment in the battle against impunity. In January this year, which, believe it or not, was only 4 months ago, the UN International Court of Justice at The Hague took the groundbreaking decision to order the government of Myanmar to take all measures within its power to protect Rohingya Muslims from genocide. And in recent weeks, a senior Syrian military officer has gone on trial in Germany charged with crimes against humanity, an important legal milestone in itself. And in a more ambiguous development, in this country, the Metropolitan Police War Crimes Unit is currently reviewing the case of 5 men suspected of participation in the Rwandan genocide, whose extradition requests from the Rwandan government were denied. So within this climate, it is the appropriate moment to ask, what are the prospects for international justice? And how effective is this seemingly renewed push against impunity in preventing atrocities and saving lives? These are some of the issues we will be discussing today. I am Tom Peake, Research Associate at the Centre for Geopolitics, and I'm joined today by Max Pensky, Professor of Philosophy and Co-Director of the Institute for Genocide and Mass Atrocity Prevention at Binghamton University, Savita Pawnday, Deputy Executive Director of the Global Centre for Responsibility to Protect, and finally, Andrew Mitchell, who has been a Member of Parliament for Sutton Coldfield since 2001, and has served as Secretary of State for International Development between 2010 and 2012. And welcome also to our truly global audience. I encourage you to join in the conversation by submitting questions through the Q&A box at the bottom of your screen. Just please type in your question and we will direct it to the panel. And please do note if your question is directed to a specific panelist or is open for the entire panel. And please do also record your name and your university or other affiliation if you have one. Now, before we get on to questions, I will invite each of our speakers to say a few words on the subject at hand, beginning with Max Pensky.
Okay, thank you. Thanks very much, Tom, for the invitation, and thanks everyone for joining. So, as Tom already mentioned in his introduction, the norm of the responsibility to protect and the norm of what's now called anti-impunity are distinct, but they have a deep history that they share. They arose roughly at the same time and under the same circumstances and largely for the same reasons. The other claim that I think that we might as well begin by making at the outset of this session is that both norms have experienced some considerably heavy weather, especially in the last 5 to 7 years. And so it's worth talking, I think, in this panel about whether those norms are still valid, which I'm going to say they certainly are, and if they are valid, how the discourses or debates about their operationalization, their applicability can best be conducted. The claim that I'm going to make here is that while the anti-impunity norm and the norm of R2P are very different, we need to go further than just talk about how they might be compatible. Rather, I think that we really need to start having a more substantive and productive conversation about how these two norms and the whole institutional framework that is developed around them can mutually support one another and can mutually correct the shortcomings that each of them has. So what I'm going to be saying is mostly about the anti-impunity norm, and I will leave the experts here to talk more about R2P. But I would just make the point that we often, when we contest these norms, and the anti-impunity norm and the R2P norm, I think that a lot of the very negative or skeptical views that we see tend, in some sense, to conflate contesting the validity of a norm versus contesting its operationalization. And I think that that's an important distinction to make, because I think contesting whether norms can be operationalized successfully can be and should be something that we talk about in some sense quite distinctly from whether the norm itself has any validity. So that's what I'm going to be talking about. I do think that the anti-impunity norm, as it's emerged over the past 15 years or so, has taken impunity no longer simply as an effect, as an outcome, as a result of other structural upstream factors like an internal conflict, corruption, poor governance, and has begun to see impunity itself, however defined, as almost a causal push factor in these sorts of problems, so that we now talk about a battle against impunity, a culture of impunity, the need to end the impunity gap, as though impunity itself were now, in a sense, a separate causal driver of these kinds of enhanced risks for the commission of international crimes. There's surely some truth to that, but it's also an artifact, I think, of something that we've only begun to really take full account of, which is the enormously enhanced profile of international criminal law over the past 15 years or so, to the detriment or to the deficit, I think, of other areas of public international law, and particularly of human rights law. So I think that we have experienced a certain legalization, as it were, of a number of different kinds of risk factors or dimensions of international crimes that we might not have been talking about in this way as recently as the early 2000s. There's some advantages to that, which I think we can talk about, but there are also some costs. One of the costs I think that I'd like to foreground is that we tend, in my view, a rather unreflective way, to assume that closing an impunity gap is going to result in increased prevention. In other words, we assume rather than document a close causal link between less impunity and greater success at reducing risk factors for atrocity crimes. And I think that the actual empirical documentation for that is actually extremely light. It exists, but I don't think that it's a slam dunk case of the kind that would continue to justify the resources and the time and the attention that is placed in pursuit of the anti-impunity project, particularly when the success stories in terms of the conviction and imprisonment of high-level perpetrators, the success stories are fairly modest and fairly few. So what I would argue for, and I think I'm certainly not alone in this, is to de-emphasize the specifically legalistic aspect of the anti-impunity norm. And actually, I much prefer talking in terms of accountability rather than reducing impunity, because I think impunity is one, and perhaps not even the most important way that societies can counteract atrocity risks by introducing and cultivating capacity for holding people, populations, political leadership, and rebel groups, what have you, to some levels of accountability. Certainly in terms of just the legal side of things, there are definitely some developments over the past year or so that we should be paying close attention to. Tom listed them all already. I think that there is after a very long lull, there is a renewed interest in the exercise of universal jurisdiction that I think is very worth noticing. I think the Karlsruhe trial of this Colonel Raslan from Syria is one of those that is potentially interesting. The Gambia v. Myanmar is certainly worth paying attention to. I'd also point out to the renewed use of Magnitsky laws, both in the United States and elsewhere, to provide alternative non-criminal sanctions to high-ranking perpetrators. But I think that we should always bear in mind that criminal justice, whether it's in the international sphere or elsewhere, is almost always a story of high expectations and modest results. And I think that there is therefore a very good reason to expand this anti-impunity norm from its current legal sense and talk instead about accountability mechanisms that are more inclusive, broader in terms of the actors or the agents involved, that can be more victim-focused, more able to deal with the collective and structural aspects of atrocity crimes than the individualized focus of criminal law. These kinds of broadened accountability mechanisms, I think, will often be much less spectacular and much less noticeable and much more upstream than the idea of the conviction and punishment of high-level perpetrators. To conclude, I think that I would, and to connect with my colleagues here, I think that it's worth talking about international justice, much less as in Pillar 3, but much more as a Pillar 2 kind of event that or exercise, one that is going to be much more interestingly taking place at the dynamic and rather messy border between law and politics, one that will have spillover effects in distinctly non-legal areas in terms of culture, in terms of social expectations, one which will have regional and subnational or local effects. I'm thinking specifically of things like the process of the negotiation of the special jurisdiction for peace in Colombia, and the way that the Office of the Prosecutor and the International Criminal Court had a different model of active complementarity for making that happen. That really is actually, regardless of how this works out, really quite interesting and trend-setting. The downside of this, of course, is it's going to be much more hard to measure, it's going to be much more diffuse, and it's going to be fully reversible. But I do think that that's one way that I'm thinking about how these norms of R2P and of the anti-impunity norm can be brought into some better, more happy relationship. And thanks very much, everybody, for your time.
Many thanks, Max. And I'll just remind our audience, please do submit any questions that you have that come to you whilst you hear our panelists speaking in the Q&A at the bottom of your screen. And again, please do mention if the question is directed to a specific panelist or to the panel in general. And please also leave your name and your university or other affiliation if you have one. And now, thank you. We turn to Savita Pawnday.
Thank you. Thank you, Thomas. Thank you for having me on this panel. And just building on what Max said, I want to begin by saying that what we have understood about the relationship between commission of atrocities and accountability is that impunity leads to commission of more atrocities, and accountability and justice provide guarantees for non-recurrence. Accountability not only provides justice to victims and their families, it can break the cycle of violence by addressing structural issues, and can act as a deterrent by sending messages to the perpetrators. Until the 1990s, with the exception of the historic trials of Nuremberg, there was almost total impunity for perpetrators of mass atrocity crimes. But with the establishment of the International Criminal Tribunal for Rwanda, International Criminal Tribunal for the former Yugoslavia, the Special Court for Sierra Leone, the Extraordinary Chambers for Cambodia, and finally with the creation of the International Criminal Court, the international community began to counter pervasive cycles of impunity by pursuing individual accountability for international crimes. And these processes have all been defining moments in the fight against impunity and for justice for victims. Steps towards accountability for the genocide in Rwanda, as well as the massacre of Srebrenica, were indispensable for the processes of justice, truth, and societal healing. While it will take a long time for victims and families to find closure and reconcile with the past, judicial processes at the ICTR, or the trial of perpetrators at local Gacaca courts inside Rwanda, constitute an important and indispensable first step. The conviction of Bosnian Serb General Ratko Mladic, sorry for my pronunciation, at the ICTY was also an important victory for the families of the 8,000 men and boys massacred in Srebrenica. It also showed that justice will eventually catch up with even the most powerful perpetrators. However, despite these successes, impunity for atrocity crimes remains rampant and is in fact flourishing in most conflict and crisis situations currently unfolding around the world. In recent years, both state and non-state actors have flagrantly violated norms that safeguard humanity. In Syria, for example, one of the oldest norms that prohibits the use of chemical weapons was violated by the Syrian government multiple times with no consequences from the international community. One major investigation by the BBC found that there have been at least 106 chemical weapons attacks in Syria since 2013. Impunity begets impunity. These attacks join a long catalogue of war crimes and crimes against humanity committed by all sides of the Syrian conflict, but especially the Assad government. But so far, the perpetrators have escaped accountability. Similarly, after almost 3 decades of systematic discrimination and marginalization of the Rohingya population, in 2017, the government of Myanmar systematically burned and bulldozed over 400 Rohingya villages and carried out a genocide against the Rohingya minority. In the Central African Republic, Cameroon, China, Democratic Republic of the Congo, and South Sudan, to name just a few, crimes against humanity and war crimes continue to be perpetrated against civilians with limited indictments, arrests, or trials. So where does that leave us? What does pursuing justice and accountability mean in practice for us today? It means that we need to deploy and innovatively use all the mechanisms and institutions we have at our disposal. This includes, but not limited to, the investigative mechanisms mandated by the Human Rights Council, as well as the independent institutions that collect and preserve evidence, local, national, regional, and hybrid courts, as well as international criminal courts. Working under the principles of complementarity and universal jurisdiction, all these different bodies can help advance the cause of justice. So let us break down a few of these mechanisms. Investigative mechanisms of the Human Rights Council. In most atrocity situations where the UN Security Council has failed to act, creation of an investigative mechanism has emerged as a go-to UN policy action. A few examples include the Commission of Inquiry on Syria, the Group of Eminent Experts on Yemen, and the Fact-Finding Mission on Venezuela. Although these mechanisms are not in themselves substitute for international justice, they are important tools that can facilitate, initiate, and enable it. These mechanisms have contributed to all pillars of accountability by establishing the facts and circumstances of the international crimes, collecting and preserving evidence, identifying perpetrators, and making recommendations regarding national truth and justice mechanisms. When the Gambia, on behalf of the Organization of Islamic Conference in November 2019, filed a case against Myanmar at the International Criminal Court of Justice for violations of the Genocide Convention, it specifically cited the findings of the fact-finding mission on Myanmar to support the call for provisional measures, which proved to be successful and is a first historic step towards justice for the Rohingya. Created as a follow-up to the work of such mechanisms is the International Impartial Independent Mechanism on Syria and the Independent Investigative Mechanism on Myanmar. Sorry for all of these different acronyms and institutions. They can be a bit confusing. Are great institutional innovations that were established to verify and preserve evidence that could be used for future prosecution in the court of law to establish individual accountability for crimes against humanity, war crimes, and genocide committed in Syria and in Myanmar. Let's be clear. I mean, as Max talked about, the road to justice is long and bumpy. It took over 20 years to prosecute Ratko Mladic, and President Omar al-Bashir is only now facing trial after being in power in Sudan for over 30 years. But by creating mechanisms like the IIIM on Syria and the one on Myanmar, we as the international community have taken the first step of bringing justice for the people of Syria and the Rohingya. I would also, as Max mentioned before, and also Tomas, want to commend Germany for the current trial of the 2 alleged Syrian perpetrators of torture and other crimes against humanity under the principle of universal jurisdiction. I hope these are only the first such cases that will ensure that perpetrators can be held accountable in courts around the world, and there is no safe haven for them. Many associate international justice first and foremost with the International Criminal Court. The chief prosecutor, Fatou Bensouda, has often said that ICC is the legal arm of R2P. the International Criminal Court remains the court of last resort and should be supported in its activities of promoting international justice. But more investment should be directed to local, national, and hybrid mechanisms that can bring justice closer to home for victims and survivors. Finally, I want to talk about one institution that does not get mentioned enough at the forums like this, and that's the International Court of Justice. The significance of the ICJ, of course, is that it's about state responsibility and not individual criminal culpability. The ICJ has already ruled on genocide in the 2007 verdict against Bosnia and Herzegovina versus Serbia, with the court deeming that Serbia was responsible for the genocide in Srebrenica in July 1995. In November, the Gambia held its responsibility to protect by lodging the case to take Myanmar to the ICJ for violating the Genocide Convention and perpetrating a genocide against the Rohingya. Such action is entirely appropriate and shows that the Genocide Convention is not just about pretty words, but is a significant right to action. The Global Center for the Responsibility to Protect, my organization, and our civil society partner, the Global Justice Center, were privileged to work directly with the government of Gambia on this case. The case has already resulted, as people mentioned before, in the provisional measures that could halt further atrocities and help the survivors. In conclusion, accountability is an essential part of how we build resilient societies, and it is an essential part of what binds us and defines us as an international community. The perpetrators want silence, indifference, and inaction, but we must continue to fight it with non-indifference, solidarity, and advocacy. Thank you so much.
Many thanks, Savita, for wonderful intervention. I believe our third panelist, Andrew Mitchell, is unfortunately having some internet difficulties. So I don't know if, Andrew, you're currently with us? It seems not for the moment. So in the meantime, whilst we're waiting for Andrew's internet to hopefully recoup itself, why don't we move on to the first question, which has already come in. And I suppose this would possibly be best directed to Savita, but I'd also love to hear Max's point of view on this. And I do apologize in case I mispronounce the name. This comes from Hila Myint from Australia, who is the senior representative of the RKAKAN National Rohingya Organization. Is R2P applicable in the case of Rohingya? And can we bypass the United Nations Security Council since it has been paralyzed in relation to invoking the intervention pillar of R2P in the case of the Rohingya? So in essence, what do we do when the United Nations Security Council is unable or unwilling to act in a timely and decisive manner, as is required by the responsibility to protect for a third pillar intervention? Over to you, Savita.
Thank you for that question. And that's a very interesting question. And I mean, at the Global Center, we constantly think about ways in which we can, protect populations and continue to sort of provide justice to those that have been subjected to atrocities. And Myanmar and Rohingya, and the case of Rohingya is particularly heartbreaking in that context. I mean, at this point, and you're absolutely right, there has been complete inaction from the UN Security Council, but that does not mean that there are no other avenues. I think one of the first steps which multiple states have taken, I mean, they didn't take it in a very timely manner, but targeted sanctions on the leadership in Myanmar is one of the ways, to sort of address your trade agreements, to cut off training of armies and providing them arms. I mean, all of these sort of bilateral measures can be taken by states to make sure that Myanmar stops perpetrating atrocities against the Rohingya. The other thing that you can also do is provide more support to the refugees. I mean, they're not called refugees, but in Cox's Bazar, and provide more asylum. So there are multiple and different ways in which we can do this. In terms of accountability, yes, we would like the case of Myanmar to be referred to the ICC, but in the absence of that, the ICJ case is a great example of holding the state accountable. So I would say that from sanctions to curtailing aid to Myanmar to sort of, renegotiating trade agreements, all of these different ways are the ways in which we can start holding Myanmar accountable. So that's the short answer to begin with.
Wonderful, wonderful.
I think
Thank
I
you.
may be back, Tom. I don't know whether you can hear
Brilliant,
me.
yes.
You hear me?
We can hear you now, Andrew. Thank you very much. And also, you might want to touch on that previous question as a member of a government who, of course, has a P5 veto in the UN.
The first two brilliant opening contributions. In this part of the world, we don't have a very strong start by making the point that, can you hear me all right?
You were breaking up a little bit, Andrew, but I think you might be okay now. I think we might have to return to Andrew again in a few minutes. It seems that there's still some internet trouble there. In the meantime, Max, would you like to weigh in on the question that we just received?
Yeah, sure. Just a few points. I mean, I do think that the effective incapacity of R2P principles to be to make their way beyond the P5 and the Security Council is it's a good example of what I was talking about before, where it's not necessarily the legitimacy of the principle that we're talking about, it's whether it's actually operationalizable. And so at this point, in specific response to the question, I think that China's veto on the P5 has basically made any sort of Chapter 7 kind of action that would come to the aid of those Rohingya who are still in Burmese territory, basically off the table. And I think that this brings up a broader question that we can certainly talk about, which is if we take R2P's operationalization as a full spectrum, are there workarounds? Are there hacks that we can do to try to bypass Security Council resolutions in some way? Because I don't think that reform at the Security Council level that would make R2P third pillar operationalizable in a way that we haven't seen either in Myanmar and Syria. I just don't see it as a realistic prospect. I really don't. And so there has to be, and so I'm an academic. I don't have the expertise or the understanding to offer a fully developed response of my own. But I think that until we finally come up with some sort of way of, and I'm not talking about coercive kinetic responses right now in terms of the far end of pillar 3, I'm talking about the full sweep of R2P kinds of measures that can be provided. I think that we have to move. I don't think that there's any real prospect of the Security Council's composition and function changing in the near future. I would say that even notwithstanding that, there is a lot of regional diplomacy that can take place in terms of pressuring the Burmese government that may be much more effective and much more results oriented than the sort of the global response. I'm thinking about regional actors such as Indonesia that still do have a certain kind of ability to put positive pressure on the Burmese government that I think that the Western powers don't. And I think that Savita was mentioning this. There is it's very interesting to speculate about what some kind of positive knock-on effects might be in terms of the ICC prosecutor's decision to open a case against Myanmar through the jurisdiction of Bangladesh, which of course is a state party to the convention, and this has resulted in the potential indictments of top Tatmadaw officials for the crime of forced deportation. So is that going to result in convictions and punishment? No, I don't think so. But I think that what we have to be absolutely interested in is, as a distinct question, what kinds of cumulative pressures in terms of the court of public opinion and in terms of other kinds of peripheral actors does that kind of measure place on the Burmese government? That's a very sketchy answer to a very good question.
Thank you. And I'm sure we'll have more on very similar topic. In the meantime, Andrew.
We can have another go if you like, but does that sound all right at the moment?
Much better, yes, thank you.
Okay, so I wanted to start off by saying a word or two about the history of
Andrew, we seem to have lost you again, unfortunately. You're back.
Yes, but I keep on going, I think, don't I?
Yes, it's a little bit unreliable. Let's return to a question and see if the internet.
Is there any way I can phone in to the program and make my submission by phone or some alternative medium?
That would be wonderful. So in the meantime, I'll put a question to our existing panelists, and I'll leave our capable Arjun to communicate with you on that separately. And thank you very much, and we look forward to hearing from you shortly. And in the meantime, there's a question which a lot of people might be wondering, and it's, what is the single biggest obstacle in consistent application of international justice? Is it the tools, or is it the political will to use the tools? And where is the biggest challenge? And perhaps Max, you would like to take that one first.
Well, I think it's a great question. I think that, the typical academic's move, I would actually dispute the terms of the question. I would say that the tools and the political will are indistinguishable. I think that those tools developed beginning in 1945. And after a decade-long latency period, beginning again in the middle of the 1990s, those tools developed and exist only in the context of the political interests and political will of state actors. And so I think that the tools as we have them, if you look, for example, at something like the International Criminal Court, which, as you know, the majority of UN state parties are members, but the majority of the world's population are citizens or residents of countries that are not state parties. So I think that when you look at something like the ICC, when you look at something like the exercise of universal jurisdiction, which is so frequently carried out by wealthy democracies in the global north toward perpetrators in the global south, the geopolitical context in which these tools have been developed means that political will and the tools themselves are always going to be intermixed in ways that are messy, that are normatively complicated, that are tough to operationalize. I think that if I had to answer the question in a nutshell, and I think that this is a very tough thing to say, is that the biggest obstacle is that the time frame for a lot of these kinds of successful measures is so long, and that the urgency for the kinds of atrocity contexts in which prevention is needed now is so short. And I think that one of the to me, as an observer, one of the biggest obstacles we face is how to compress somehow the time frame for effective capacity building, effective structural reform, effective prevention efforts in ways that have any relationship to the urgency of the kinds of atrocity contexts that we actually have to deal with.
Savita, might you have a...
Yes, absolutely. I mean, that's a really good question. And I think that it's I mean, just to build on what Max said, I think it's a combination of both, because I think the people, I mean, the individuals or the institutions or the governments that are in charge of sort of imposing the will are also the people who make these institutions. So in Geneva, the creation of a certain investigative mechanism is a political process. It's a question of will, but it's also about, you know, how we design the mechanism, the mandate of the mechanism. So it's a combination of both those things. But at the same time, I think that the sort of additional question too is the fact that what kind of institutions are we talking about? I mean, it's not only just the International Criminal Court or the international mechanisms. The problem, the big sort of, and I mean, the impunity gap, which sort of Max talked about before, and sort of, you know, departing from that space or that argument is the fact that, I mean, there's such a big accountability or justice gap at the local, national, regional level. And that's where the problem is at. I mean, with the Commission of Atrocities, in most cases, it's actually the government which is the primary perpetrator. I mean, most of the cases that we have talked about till now, it's the government which is the primary perpetrator. So here we are stuck in a system where we are asking governments to punish themselves, and that is the essential problem. And as a result of which, accountability measures at the national level are, you know, in most cases are pretty weak in terms of holding a government responsible, in terms of sort of, you know, initiating any kind of preventive action or constitutional reform that can then sort of, you know, curb the government. So I think that for us, the question is not about sort of whether there's political will or whether we have the right kind of institutions. It's that which kind of space are we talking about? I mean, at the international level, we have still made a lot of progress, but the big sort of gap still exists at the domestic, at the regional level. And that's where most of the heavy work has to happen, because although international mechanisms are very important, ICC is very important, justice which is closer to the people, justice which is restorative, justice which mends societies and allows it to sort of move forward, is something which happens at the national level. And from the experiences in South Africa to Argentina to East Timor, what has become most essential is the fact that what kind of mechanisms you know, are to exist at the domestic level. Thank you.
Thank you. And it seems like we have Andrew back, but unfortunately, Andrew, you're muted. So if you'd...
Am I muted now?
No, there we are. There we are. That
Okay.
seems...
Good. So we'll have another crack at it. I wanted to start by saying something about the history of all of this, because when the genocide took place in Rwanda, it followed on from Black Hawk Down in Somalia. And that had been a salutary lesson for the world superpower, America, where they'd been humiliated on the streets of Mogadishu. And so when in 1994, the genocide took place in Rwanda, there was no willingness from the Security Council to take action. And in particular, the French made it clear that they regarded this as a civil war and not as a genocide. And then we had, towards the end of all of the terrible events that took place in Rwanda, we had the spectacle of the international community being unwilling, first of all, to recognize what had taken place and then to do anything about it. And after the Holocaust and the Second World War and events in the 50s and the 60s, we said never again we were going to stop as an international community this happening. And on the back of that, Gareth Evans, the former Australian foreign minister, managed to negotiate through the Security Council, even with the support of the Chinese, the principle of the responsibility to protect. But the problem was this was a skeleton. It never had any flesh on the bones of what it actually meant. It asserted that international, that national sovereignty could be trumped in a case of genocide by international action, something, as I say, the Chinese even put up their hands for. But in the end, it didn't have any bite, it didn't have any engine behind it, and we saw what happened in Darfur, which after all George Bush, the American president, described as a genocide. We've seen what's happened in Burma, where the UN's made it pretty clear. They call it ethnic cleansing, if you like, but there's clearly, as Savita was saying, there's clearly evidence of genocide amongst the Rakhine coming out of Rohingya state. And then you have Syria, where not only has there been impunity, but there has also been a member of the UN Security Council either actively participating or passively acquiescing in the use of chemical weapons against all the conventions which the UN should support. So the principle of the responsibility to protect has been and continues to be under very great threat. And at the moment, the international system is moving backwards as we see this rule by strong leaders, whether it's Putin or Xi or Sisi in Egypt or Modi in India or Trump in America. You know, this is antipathetic to the international rule of law, international cooperation, upon which any progress on R2P depends. And the British Foreign Office has been trying to collect evidence of atrocities in Syria. They set up, when I was on the National Security Council, we set it up, a sort of database where mobile phone photographs and so forth could be used, because, you know, modern technology means it's more difficult now to hide away these terrible acts. And I think that there were two other points I really wanted to make. One is that, you know, for progress on this, we need reform of the UN. And I have great faith that Antonio Guterres, who I think has turned out to be an extremely strong and good Secretary General, when and if he is re-elected to his second and final term, I do think that he will start to try and do something about the UN, which needs to be modernized if it's to make not just R2P, but in a whole series of other areas, make successful reform. You know, we have a settlement at the UN which depends upon the victors in 1945 of the Second World War. There are no African countries or South American countries on the UN Security Council. You know, it's ripe for modernization. I suspect that such modernization will lead to a diminution of the veto, putting more power into the hands of the General Assembly, but that will have to be negotiated with the veto wielding powers. Now, it's not just in any criticism on all of this, it isn't just the poor world, you know, who, for example, many countries in Africa feel the ICC has been a tool of neo-colonial oppression. I think that's a very unfair judgment. I mean, after all, the intervention of the ICC over General Bashir over Darfur was an example of the ICC standing up for Africans against what was effectively Arab oppression at that time. But my point I want to make is this, and you referred to it, Thomas, in your opening remarks, is it's not just the poor world that feels aggrieved about the failures of R2P. In Britain, we have today 5 alleged genocidaires who are wandering around Britain. They're claiming benefits. They've been in receipt of enormous amounts of British taxpayers' money as the courts have failed to bring them to account. First of all, by the very long process of appeal against the decision of the British courts not to extradite them to Rwanda, in spite of the record of Rwanda processing through the Gacaca courts that were referred to earlier, in a more limited way through the Arusha trials. But in spite of that, Britain, unlike many other countries, refusing to send back these alleged genocidaires, 2 of whom are accused of the most heinous of crimes, and they're wandering around Britain, not being held to account. They have been doing so really for 11 years, and the British legal and judicial system, having failed to extradite them, is now taking an enormous amount of time to hold them to account, hopefully through the British courts. Now, this is a very serious matter, because if Britain, which in many dark places in the world, through its role in the UN Security Council, has been a very bright light at times of deep conflict and misery, if Britain is allowing impunity in the case of these alleged Rwandan genocidaires wandering around our country, then it not only flies in the face of everything Britain has done to hold to account down the years those responsible for the perpetration of evil crimes under the Nazi regime against Jewish people in Europe. People in Africa begin to feel that there are different rules for white Europeans to what there are for defending the rights and human liberties of black Africans. And there's many people who feel that this failure on this very basic level to hold these people to account, these 5 genocidaires in Britain, not only undercuts Britain's international reputation, but also does great damage to the fight against impunity and to the growth of international law and all the things that R2P is supposed to stand for. So I make that point not just to be self-critical of Britain, but to make the point that all of us have to do our bit to tackle the culture of impunity that exists at a very difficult time in the world for the international humanitarian system, the international rule of law. All of us have issues to address. And I hope, as I say, this all might come together conceivably in Antonio Guterres' second term as the UN Secretary General.
Many thanks, Andrew, and it was certainly worth the wait of through the technical difficulties. I suspect that Savita might want to respond to some of the remarks about the responsibility to protect before we move back to questions from the floor, if you would like, Savita.
Yes, I mean, thank you for that intervention, Andrew. And I think that to say that that R2P is a skeleton and it doesn't have that much sort of, you know, for the lack of a better word, flesh on it. It's, I think that it's a little bit of a mischaracterization in that regard, because over the years, I mean, since R2P was adopted in 2005 in the World Summit Outcome Document, I mean, the different reports of the Secretary General have expanded on how to implement R2P, and it's not only sort of solely about this Pillar 3 intervention. I mean, that part is an extremely important part of the tools in the toolkit of how you implement the responsibility to protect, but that's not the only sort of measure that we have. I think that it's important to sort of emphasize, and what I sort of talked about in my response earlier was the importance of Pillar 1 of R2P, that is the state responsibility, and the different things that we can do to enhance that responsibility. Then there are sort of a host of measures and tools within the Pillar 2 of R2P. So the Pillar 1 about state responsibility, there's so many things that a state can do to make sure that they become better at preventing future atrocities. And it's not as if we don't have enough examples. I mentioned Argentina, South Africa, East Timor. All of these countries have emerged from heinous atrocities which have happened over a long period of time, and they have taken steps in terms of memorializing, you know, and accountability, or sort of transitional justice mechanisms have taken different shapes and forms in all of these different countries. Some have gone the punitive route, some have, you know, sort of privileged the whole idea of truth. So there's so much that we can learn in terms of enhancing the Pillar 1 responsibility of states. The UN does a lot of work, regional organizations have done a lot of work, EU has done a lot of work in terms of sort of enhancing this capacity of a state. The sort of second pillar aspect of it is, and I mentioned this in my response on Myanmar, that you know, there is the UN Security Council, and what we have increasingly seen with the UN Security Council, I mean, you know, let's not even think about Myanmar, which is, you know, which happened in 2017, but from 2011 on Syria, we have seen a complete abdication of responsibility, for the lack of a better word. I mean, in Yemen, the P3 have been involved in sort of, you know, being party to the Commission of Violations of International Humanitarian Law. So, I mean, I don't think it's all, I mean, we have a tendency within international conversations to sort of focus too much attention on the UN Security Council. Yes, absolutely, it's an important body. It is in charge of the peace and security in this world, but there are different mechanisms which can also be helpful in sort of shaping our response. That cannot be the only avenue, and especially when that avenue has been so sort of stuck in this mire. We have to think about creative ways in which we can, start thinking about not only accountability processes, but other things. So again, as I mentioned before, there's a lot of bilateral action that can happen. There's a lot of regional action that can happen. Max mentioned the neighbors around Myanmar can put a lot of pressure if they actually want. So I think that it's important that we start sort of thinking about response to atrocities, not only in the framework of coercive measures and the UN Security Council, but start thinking about it in terms of sort of more broader mechanisms that exist, which can be about enhancing state responsibility, which can be about bilateral or regional aid. And I can go on about this, but I'll stop right there.
I think, can I just say, Thomas, can I make two points on that? I mean, the first is that Syria is a very good example because the United Nations very nearly got a solution when Kofi Annan tried to broker a solution. And he said that Assad would go in a subsequent election, but would be part of the negotiations. And the Americans vetoed that. And to our, I believe, collective shame, we vetoed it as well. And many thousands and thousands of people have died since that time. So the UN did try to intervene, but in the end, the sort of non-international approach, the significant countries refused to line up about it. And I think that shows you why it's so important that if you don't get the UN on side, if you can't function through the UN, you're starting way behind the line. The other point I would just like to agree with is on Yemen. It's basically the British and American, has been appalling.
Andrew, I think your reception might have.
In the
So I think Andrew's reception is unfortunately interfered with again. We might have to move on to another question again at this point, and we have one here which is directed at Max specifically, and it comes from Aslihan Turanzara, who is a teaching fellow at the University of Birmingham. And the question is, do you think that the discussions held around crimes, do you think that discussions should be held exclusively around crimes committed in the South? Or for the anti-impunity norm to be successful, should it be considered more globally? The USA, for example, not being a party to the Rome Statute, and the UN Security Council voting system, as we've spoken about, being dependent on the state level, do these make the anti-impunity norm difficult to, does it make it difficult for the anti-impunity norm to achieve its goals?
That's a great question, and I'd be happy to have my other panelists weigh in too. And the answer is absolutely it does. Absolutely it does. And so I think that this is one of the major discourses that we've seen ever since 2002, certainly, when the International Criminal Court came into effect, when the Rome Statute reached its necessary threshold of 60 members. That if you look back at the first prosecutor, Luis Moreno de Ocampo, for better and for worse, Ocampo had a tremendous problem of trying to walk this impossible line between, on the one hand, with the statute of limitations, the temporal statute of limitations of 2002, and with the realization that the major powers are not parties, and the United States was and continues to be extraordinarily hostile to the International Criminal Court. I mean, the hostility now is so extreme that everything in my country is extreme right now. But I mean, my point is this: that it was in many ways a virtually impossible task to try to shoot this rapids between accepting cases that were relevant, that were sufficiently grave, that were prosecutable, and that had a realistic prospect of convictions on the one hand, and on the other hand, establishing the very real possibility that this would be seen as a European court for the prosecution of Africans. And I think that I agree with Andrew that that latter, that there's something deeply unfair about that latter characterization, but you can understand it. And I think that given the geopolitical realities that we face, I think that the court is going to have tremendous difficulties extending accountability to the great powers. I think the United States in particular, I think that the outgoing prosecutor's decision to open a case in Afghanistan recently that will include not only Afghan citizens, but US intelligence personnel, presumably, will be a tremendously interesting, not in the for the prospect of success, if by success you mean successful convictions, but by success in this broader sense that I'm pushing for, which is to move somehow the global conversation forward about how accountability can be extended to great powers that are never going to be state members to the Rome Statute.
I don't know whether my comments on Yemen got through, Thomas, or not, but the comments I was making was just to say that the British and the Americans were culpable there and in breach of their responsibilities, in my view, on the Security Council for the way in which Yemen was handled, where actually Britain holds the pen on the Council, but was not in a position really to lead within the UN because of that.
Many thanks, Andrew. And I'm very conscious that we've only got a limited amount of time left, and we've had many very fantastic questions. And so we'll move to this one, which comes from Ananyan Siriam from the University of Leeds. How can R2P be applied to China's crimes against humanity in Xinjiang against the Uyghur minority? And of course, this builds on many of the topics we've already been talking about. And Andrew, whilst we've still got you, would you like the first go at that briefly?
Well, the question, which is a brilliant question, underlines the problem, which is that the veto powers exercised by the permanent members of the Security Council are such that unless we have much more policy and case law on the R2P, we're not going to make progress. The great skill with the Chinese was to get them to sign up to R2P in the first place. But the question underlines how far we have to go to make this really effective. And
Savita, would you like to briefly?
Yes, absolutely. I mean, I'm not going to go into the question of the UN Security Council. We all know that with China being a P5 member, I mean, there's not going to be much avenues there to explore. But I think that you know, concerned states. I mean, what is happening with the Uyghur population in China is a crime against humanity. And I mean, what we would like to do is to sort of you know, talk with supportive governments, and there is some momentum right now in Geneva with the Human Rights Council and with the concerned states to then sort of get the UN High Commissioner to at least be able to access the region and to possibly send a monitoring or a fact-finding mission there to sort of just even, you know, see to the situation. So I think that that's where, I mean, that's sort of a start there. And the other thing that we would suggest, again, is targeted sanctions. I mean, that can be another way in which we can think about sort of holding China a little bit responsible. I mean, and this is not to say that China is not sensitive to criticism on this. I mean, I think a few months ago, I mean, when we could all travel, I remember when there was a lot of sort of momentum, especially after the last, the September session last year in Geneva. I mean, they had all of these different sort of kiosks around the human rights, I mean, around the Geneva UN building, which sort of talked about, you know, the China's record on human rights and everything. So I think they're not insensitive to criticism, and maybe now with, you know, what is a backlash against China internationally because of COVID-19, they might be even more open to more pressure. So I think that we have to explore different avenues of at least starting to record or monitor what is happening with the population there. At this point, like, there's very limited information coming out. Thank you.
Many thanks, Savita, and unfortunately we're out of time. And Max, you'll have to forgive me if I don't give you an opportunity to address that question directly. And it's now time to bring a close to this video panel on R2P, International Justice and the Battle Against Impunity from the Centre for Geopolitics at the University of Cambridge. I would in particular like to thank all of our audience and for your wonderful questions. We had many, many questions tonight, and we were only able to touch on a very small number, and thank you very much. And I'd also like to thank again our panelists, Max Pensky, Savita Pawnday and Andrew Mitchell. Please do check back shortly on the Centre's website, which is at www.cfg.polis.cam.ac.uk. That's www.cfg.polis.cam.ac.uk, where the video of this discussion will be uploaded in a few days. And I hope also that you will be able to join some of our upcoming panels. We'll be back next week, Wednesday the 20th of May, at the earlier time of 9 AM here in the UK, where we'll be co-hosting a panel discussion with the Asia Pacific Centre for Responsibility to Protect, looking at developments in that region of the world. And I imagine the case of China will feature heavily. And we'll be joined by Alex Bellamy, Noel Moreda, Sarah Teat, and Riza Hasma. Then the following week, Wednesday the 27th of May, we'll be back at our usual time of 6 PM UK time for a conversation on the politics of emergency shelter. I do hope that you will be able to join us then, and thank you again from the Centre of Geopolitics, and we'll see you soon.